The Court of Appeals is now in session.
Good morning and welcome. As Lisa said, welcome to the Court of Appeals today. We have several matters on our calendar this morning, and in which we will hear arguments. The first matter is in the matter of DR. I'm joined today, I am Judge Michelle Christensen Forster, and I'm joined today on the panel by my colleagues, Judge Ryan Tenney and Judge Kate Appleby. Thank you, Judge Appleby, for helping us out. We really appreciate it. Counsel, if you could please enter your appearances for the record, and Ms. Pearson, Mr. Peterson, if you could let me know how you plan to divide the time, I would appreciate that very much.
Greg Stevens here on behalf of the mother.
Martha Pierce, attorney guarding ad litem for the minor child. We intend to split our time down the middle.
Thank you.
And John Peterson, Assistant Attorney General for the state of Utah.
Perfect. Does anybody have any questions? I know you've all appeared many times in this virtual format. I can't imagine that you do have any questions about how we are going to proceed, but just the one reminder that when you are not arguing, if you wouldn't mind, please turning off your camera and muting your microphone. That will help us pay attention to whoever is making argument at that moment. I don't see any questions or any other things that we need to discuss. So, Mr. Stevens, please begin whenever you're ready.
Thank you, Your Honor. Good morning, and may it please the court. This case, I think, is a case that falls outside of the cases that have come before the Supreme Court, the Utah Supreme Court and the Court of Appeals before, where someone has raised a claim under the ADA. The mother in this case, through counsel, raised the ADA, the request for an accommodation in her Rule 59 motion after the court, the juvenile court had decided and changed the permanency goal, in this case, to adoption.
Mr. Stevens, should she not have raised that earlier?
Yes, and she did. At least the mother did. The mother in the report that went to the court, I think is July 8th, or for the review hearing, July 8th, 2021, the report says that the mother informed DCFS on multiple occasions before that report was issued that she had suffered from AVM, and I'm not going to, it'll take 15 minutes for me to try to pronounce it correctly, suffered from AVM, and that the condition resulted in her having brain aneurysms and minor strokes. So the mother did raise it. Her counsel didn't raise it with the court, with the juvenile court yet, but this was the report that was prior to the July 8th, 2021 review hearing, was reviewed by the court. Go ahead.
Let me just, I'm sorry to interrupt, but she notified DCFS that she had this condition, but did she say this condition means that I need more time for everything?
No, that is, the mother didn't, not until the Rule 59 motion. But in this case, I think it falls substantially before every other case where the person, the parent, raised the issue of the ADA at the termination trial, which the court in KC said you could do, although it makes the possibility, it certainly factors into whether a reasonable accommodation is possible that late in the game. But in this case, it happened well before the termination trial, and she did raise it, and she did request specifically as a reasonable accommodation simply more time for her to be able to complete the tasks that were required of her under the service plan. So
can I just dig into that just a little bit? Sure, maybe she could have used more time to complete services or to and have a few more therapy sessions or have a few weeks of negative drug tests. But my understanding sort of the facts, and I'm hoping you can clarify this for me, is that she hadn't even gotten to that point yet. She hadn't drug tested, she hadn't completed, done what she needed to do to where more time would have helped her to complete what she needed to complete. And maybe that's just too general of a question, but my understanding is she wasn't even in a position that more time would have helped her.
I think I think it's a fair question. Is she was doing the drug testing. Problem is she wasn't always showing up for the drug testing, and I believe she actually tested positive on occasion before. And I don't know if I have my timeline correct before the termination trial in any event. But like I say, this case, let's say take the CC case where that was, I think, 17 months. This case is decidedly on the other side of that equation, where the child was removed from the home in March 2021, and I think the services were put in place in April 2021, and then the court changed the permanency goal in July 2021, and then had the termination trial in November 2021. So it's substantially less time, and I think with the child doing well in the temporary placement, I think the court could have easily, as a reasonable accommodation for the disability, afforded that additional time. Now, I think it's certainly up to everyone's speculation whether she would have been able to comply with an additional 30 days or 90 days. I don't think we know that, but to give her that accommodation and give her that possibility, I think was what the ADA had required. And the court actually acknowledged that she had a disability, although the juvenile court glosses over this in its ruling denying the rule. Go ahead, I'm sorry.
No problem at all. This is sort of a piggyback off of Judge Christensen Forster's question, but one of the things that jumped out to me as I read the juvenile court's order is the judge has all these findings about mother not communicating with various people involved in the process, whether it be her own counsel or DCFS and so forth. And so if the thing that we're thinking about in this appeal is whether there should have been a reasonable accommodation of more time, but we have all these findings that haven't been challenged, that she's not communicating with people at various steps in the process, I'm not sure what more time gets her. Why isn't the assumption there that if she's missing appointments and she's not communicating, that giving her more time is just going to be more time in which she's still not going to be communicating and still missing appointments? And at that point, I mean, this is my real question, is the ADA doesn't require all accommodations, it just requires reasonable accommodations. Why wouldn't we or the juvenile court just look at this and say, it's not reasonable to give her more time when she's not using the time that she's already been given? I hope that question makes sense.
No, I understand what you're saying. I think the juvenile court's conclusion, errs on the wrong side of that. I think if you're going to give someone a reasonable accommodation for a disability, you take the side that she be given this opportunity for the reasonable accommodation she's requested. I think what you're doing is assuming, and I think what the juvenile court did is assumed that she's been given this time so far, no more additional time is going to matter. But even in the report the DCFS had filed record at 186 is that where she does mention, and it says that she has told DCFS repeatedly that she suffers from this. It's part of the same discussion where she talks about missing meetings and then having serious headaches and requiring treatment for these conditions. So I think that in analyzing whether a reasonable accommodation under the ADA is appropriate, I think you should err on the side of affording that accommodation. And I think you're right. I think what the juvenile court did was essentially was unhappy with the fact that she didn't use the time that she had. But in this case, it is by far shorter than any other case that's come before the Supreme Court of the Court or the Court of Appeals in granting the accommodations or the reasonable accommodations that the person's requested at, or the parent requested at the termination trial. So in
So-
this case, go ahead.
We've got a couple of questions pending and I defer to the presiding judge.
You don't need to do that, but I have my question is directly related to Judge Tenney's question, and that is in an ADA case like this, the court, the state must give a person with qualifying disability reasonable accommodations to complete the reunification services, to do what she needs to do. But this is a case, this case involves a juvenile. And it seems to me the further we get down the line, the importance of permanency and stability for this child, this 8-year-old child, how do those two factors compete? And how do we analyze them together in juxtaposition?
I think what the court in KC had said was that when the person raises the ADA accommodation matters for those issues and for those considerations. In those cases, as you know, they raised it at the termination trial. It was both before and immediately after the change in the permanency goal, and that was in July 2021, still several months in advance of the termination trial. And then at the termination trial, it wasn't considered by the court in its final order whether or any analysis of the ADA. And it seems that in this case, and I think what you're being asked to decide is, when is it reasonable to raise that? Do they have to raise it by way of a motion with the court early on, before even there's a change in permanency, or at the start of the process? That would be the easiest case, I think. This one, I think, falls somewhere in the middle, before all the other cases, which was the termination trial, when the courts have said clearly it's too late. If they had raised it in March 2021, that would obviously be something that the court would consider, or would be called upon to consider. But in this case, it's right at the permanency hearing. So is that sufficient? I think so, because it was in advance of the actual termination of her parental rights. Given the opportunity, she could have at least arguably completed the services. And I've used my time.
My question was more or less the same as Judge Christensen Forster's, so thank you.
Thank you, Mr. Stevens.
Thank you.
Ms. Pierce?
Martha Pierce, attorney guardian ad litem for the minor child. In this case, you absolutely cannot fault the attorney or the judge, because the best practice for an ADA claim is to get an assessment. That way you don't have to go off a fact sheet from the internet. You don't have to go off of Wikipedia. You can get an assessment. And in this case, that's what the attorney obtained. And he did that prior to the adjudication hearing. The judge ordered mother to get an assessment. And I read about 30 assessments a year, and they're amazing. They have all these educational testings. They explain how a parent processes information, how they make changes, what kind of accommodations you need to make. And so at any point, if mother had raised an ADA claim, HHS would recommend that the first thing you do is you get an assessment. You don't just say, well, let's give you more time. You have to tie it to the disability. So that assessment was always on the table. That was ordered early in the game. So you can't fault the judge, you can't fault the attorney. And mother never got that assessment. So that's point number one. Point number two is, to show that you're a qualified individual, you have to show that with or without services, with or without a disability, you are entitled to these services. Well, NRA AT 215 Utah 41 says that services follows the permanency goal. So mother, when she raised ADA, would first have to move to change the permanency goal. NRA KC says that a late claim means what you're really asking is for the court to reopen the reunification period, which means to say you were moving to change the permanency goal. Mother never even attempted to do that. And at that late stage in the game, I think it would have been quite an uphill challenge to say that changing the permanency goal back to reunification under the statute would have served the child's health, safety, and welfare. And by that time, you also had a lot of factors that would have, under the statute, presumed against services. Now,
So maybe I'm just confused, but she did ask for, wasn't her Rule 59 motion, didn't she ask for basically to reinstate the reunification period, the services themselves?
she did, but she
But
didn't.
that was too late.
No, I'm not saying it's too late, but what I'm saying, there's a way to ask for the permanency goal to change. And under the statute, you have to show that it serves the child's health, safety, and welfare to change the permanency goal. So she didn't make a claim. Her claim was all about her, and it wasn't about the child. And the permanency goal is a very child-focused issue. And so the judge had already changed the permanency goal, and she wanted to change it back. Now, if you look at sections 406 and 409, the first one is the disposition, 409 is permanency, but almost every other subsection talks about how much discretion and how broad discretion the court has to shorten the time period, but to lengthen the time period requires making some very distinct statutory findings. So in other words, there's great discretion to shorten that time period, very little discretion to lengthen the time period. And in this case, where you have things like severe abuse, severe neglect, an uncooperative mother, you just don't have, she just did not have a case to change the child's permanency goal. So my two points are, one, you really cannot fault the judge because an assessment was on the table at all times, and that would have helped everybody understand what kind of accommodations were appropriate for this mother. And number two, to show that she's a qualified individual, she would have first had to put on the burden of production and show that it would serve the child's health, safety, and welfare to change the permanency goal back to reunification. I think this was a best practice case. I don't think you have a claim of error. And unless this court has further questions for me, then I will leave it to my colleague. Thank you for your time.
Thank you, Ms. Pierce. Mr. Peterson?
Mr. Peterson, before you get going, can I just ask you a practical question?
Oh, let me just make the appearance, just recording. John Peterson, Assistant Attorney General for the state of Utah. And yes,
Yeah,
definitely.
Thank you. And so my question is, if we were to reverse, what happens?
I guess it's a little bit open-ended. I guess it depends on exactly how. I mean, assuming that the court reversed, basically finding that the ADA had been violated and that mother was, let's say your ruling was that the ADA had been violated and mother was entitled to a reasonable accommodation, which would be more time. Then I suppose that you'd have to remand the case and give her some more time.
But what would that look like? I mean, another 30 days, another 90 days, reset the whole thing?
I mean, it's a little bit sui generis. I mean, because there's timelines built into the law, but once you add in the appellate timelines and the time for briefing and remand, then certainly those timelines have gone out the door. But I think, were this court to determine there had been some kind of violation and their rights had not been acknowledged and treated properly, then they would have to be, regardless of whether or not the statutory timelines have come and gone.
Thank you. And it's probably, I mean, I have no idea.
Okay, but
Maybe
I'm just
that's
the
somebody
general.
else to decide, but I just wondered, as a practical matter, what would we do?
It's always on you. I mean, it always puts you in a difficult position. But I think if the court rules that someone's rights were need to be vindicated, then those rights will have to be vindicated, regardless of whether or not it's unfortunate for the child and everybody involved. But
No, and I agree with that as a sort of general proposition. But given the nature of this ADA claim, I'm just not sure what that looks like.
yeah, but I mean, I certainly would. I mean, I say, well, it would be possible. I would argue that this case not a case, where her rights were violated whatsoever. I mean, given the facts of this case, really, I mean, Mr. Stevens is correct that this case is not a case where you raise the ADA very last minute, in closing argument to your termination trial. But it also could have, I mean, the ideal time, obviously, to raise an ADA claim would be right up front when you're creating a service plan and to tell people, look, I have this disability and it affects me in X, Y, Z way. And it would be nice to have these things in my service plan because this would really help me to perform. I mean, and the problem with this case is even when she raised, I mean, I don't think anybody denies that she has this AVM condition, but it's not 100% clear or even very clear that it really had any effect upon her whatsoever. I mean, basically, all she said is, well, look at, here's the definition of AVM. It has all these symptoms, but she's never actually said that she has any of those symptoms, and she's never really identified how it precisely affects her. Yeah, yes, Judge Kenny.
Yeah, but I understand the point from the blue brief to be that once the juvenile court is put on notice that she has this condition, so the juvenile court itself has something of an affirmative obligation to at least inquire and sort of figure out the scope of her disability and what it should be doing to accommodate it. And so once the court is put on notice that she has, I'll go with AVM as well, there's no way I can pronounce it. Once the court's put on notice that she has AVM, why isn't it at least incumbent on the court to be saying to her proactively, what do you need? Do you need more time? And that sort of thing. Because I understand that to be the thrust of her position, is that at bare minimum would have been the thing that the court was required to do. Why is that wrong?
I mean, if you look at all of the cases from the Utah Supreme Court and this court, I mean, there's been some statement about obligation, but really, I mean, the way I read the cases is what the court has an obligation to do is consider request under the ADA, because I mean, it's only the person themselves is the one who knows. I mean, and really, there's a bunch of cases that say, why is it up to the court to speculate as to what may or may not have helped? I mean, there's really never been, other than it was a last minute, like, well, maybe some more time would help, but they never really said like what it is about her condition that makes her unable to do things on a timely basis. And really what the court found is that she doesn't do anything. She doesn't even show up to court. I mean, she didn't communicate with counsel for 3 months before trial. It wasn't at her termination trial. She made 9 out of 16 visits, I believe. She missed her child's birthday visit. She missed most of her drug testing. When she did drug test, she tested positive several times. I mean, and I think the court made an extensive ruling on her ADA claim. Here, I mean, and basically said, all she's ever requested is more time, which she never requested until that point, until well into the case after having done nothing. And the court said, in light of this child needs permanency, you haven't done it. Giving you more time and allowing you to kick this down the road is not helping anybody, you or the child. And I mean, I think that was a reasonable ruling by the court.
Would it be fair for us to interpret that part of the ruling as the court implicitly, if not explicitly, saying, I don't think the accommodation would be reasonable, or is that reading that portion of the ruling too far?
I mean, I think the court both found that she hadn't ever really established how it was. I mean, that she was qualified and how it was that this disability actually affected her. And the court also found that it was not, especially this is not a reasonable modification. And again, counsel keeps arguing that some kind of affirmative obligation for the court to, play junior doctor and ferret out things. But I mean, all of this courts, you look at the KW case, I think it's very instructive, 2018 Utah App 44. The court there noted that, father never requested any modifications. And so the court said, we are left to guess whether father's failure to participate in services was due to an inability or an unwillingness. Again, I mean, you have to leave some of this in the person with the disability's lap. I mean, if you don't tell us what your problem is, and then why is it up to the court to play this guessing game and to, I mean, I think they said in the brief, mom says, that the DCFS could have gone online and looked up AVM and see what it involves and how to deal with it. I'm like, but it's like saying you have MS. It's terrible and unfortunate, but how is it affecting you? What is it? You have serious MS? Can you move? Can you walk? I mean, what does this AVM do to you?
Right, but then pushing back on that a little bit, why wouldn't it at least be incumbent on the court in that circumstance to say, I've been alerted that you have MS or AVM or whatever the condition is. What do you need? Or what is it you think you need from me in response to that condition? Why wouldn't we say that the court at least has that obligation?
I mean, I think I would really just be a pushback that's really up to her to request it. I mean, because there's been no evidence that other than an unwillingness to do anything. I mean, I guess maybe the court could have said, what do you need? But But I mean, but she is. I mean, she's appointed counsel. She has counsel throughout the case, and all of. I mean, throughout. I mean, even up July 8th. You know, she appeared in court. That was only 2 weeks before the permanency hearing, and said, you know, that DCFS has made really considerable efforts. You know, and I've accomplished some things now. I've got a car. I think I can get around, and I really could just use some more time. Because I'm going to start trying now. And there was never any suggestion that but you know what? Half the days I wake up and I can just barely function. I can barely get by. There's never been any even the slightest statement that this condition is really hampering me. I mean, that not even the slightest, other than just like, just the generic claim, which is, yeah, it'd be great. I think I could use some more time. But why? Why do you need more time? And I guess I see I have used my time. I hope that was responsive, Judge Tenney.
It was, thank you.
Thank you, Mr. Peterson. Mr. Stevens, your 4 minutes on rebuttal.
Oh, okay, I thought I had used up all my time. What I think Judge Tenney has the gist of our opening brief correct, is that we do think that there is an affirmative obligation, and I think the cases make that clear. The CC case and the KC case make clear that there is an affirmative obligation on the part of the court to make an inquiry, and that the court even noted in its change in permanency order, or actually review hearing order, the July 2021 review hearing, that she suffered from a disability. I think that's on the record at 228, where the court notes that, but then there's no discussion of it, and then in the Rule 59 motion kind of glosses over that and says it's not a finding of fact. So I think the court knew at that point, even before the Rule 59 motion, was that she suffered from a disability. And I think both in the report, which I think is the record at 186, the court was apprised of the fact that she suffered from this disability. And I think based on the Supreme Court's case and this court's opinions, that there was an affirmative obligation on the part of the court to make an inquiry.
He has a question, and I do too. So
I'll defer to you to go first if you'd like.
Well, it's just a quick one, and it goes back to my first one. When did she first raise this? And not just saying I have this condition, but I have this condition that requires assistance to be able to meet my goals.
I would say definitively, certainly in the Rule 59 motion. I think the report, the July 8th, 2021 report at the record at 186, notes that she repeatedly raised the fact that she suffers from that, as well as what it did is that she suffers, has brain aneurysms and strokes, and that her mother and father and brother confirmed, and that she requires care of neurosurgeons who specialize in the condition.
Okay,
it doesn't.
So when did she get the court-ordered assessment?
All I know is that she had an initial assessment. I don't believe, and I think counsel, the guardian is correct, is that she did not get an assessment of her disability that was filed with the court.
Okay, thank you. Judge Tenney.
Let me jump in with a question. I'm wondering if you could respond to the point that John Peterson made, and let me parrot it back and get your response to how I heard it. His point, I take it, is this. Even if a parent or a litigant in a general case says to a court, I have this condition, this disability, that doesn't necessarily mean that they're symptomatic. And even if we know they're symptomatic, we don't know if they're mild, moderate, severe. And then from that, we don't necessarily know what accommodations they do or don't need. That all requires a lot of really specific information. And so what I understand the state's position to be is this. If we're saying to the juvenile courts, you have an affirmative obligation to come up with accommodations on your own, we're asking them to do a lot of sort of mind reading or even body reading that they're not really factually equipped to do. So why isn't the better rule here to say to the litigant, look, you need to tell the court, these are my symptoms and this is what I'm requesting. And if you don't, then the juvenile court doesn't have an obligation to affirmatively go out and imagine stuff for you. Why is that not the better rule?
I think, I think that goes against the Supreme Court's decision in KC, as well as this court's decision, saying that there is an affirmative obligation of the court and DCFS to explore the ADA as well as when someone has raised the fact that they have a disability. And I think that she actually does more than Counsel for the State has said is in that report at 186, it does explain what her symptoms are, does explain the fact that she has to be treated by neurosurgeons and has been admitted to the hospital to treat it. And I can't, without speculating, say, why she hasn't received treatment, although it says that she's afraid that she won't survive the surgery, at least in this report. So I think there's more here than the state's attorney has said that she has raised. She didn't simply say, I have a disability, and you're left to guess. It's been raised with the court, and the court knows this is the report's filed with the court, and the court considers it the juvenile court prior to the its ruling changing permanency. So it was raised, and I think that at a minimum triggered an obligation on the court to say, well, get an assessment at the very least.
But even taking all of that as a given, if I'm putting myself in the juvenile court shoes, okay, I now know that she has this condition. I now know that she needs surgeries and so forth and so forth. But I don't necessarily know that she thinks that she needs more time as a result of this, unless she says that. I don't know if what she instead needs is something else. Yeah, I don't know what those things are because I'm not a doctor. I'm a judge, right? And so I'm worried a little bit that if we wrote the opinion that I think you're asking us to write, we'd be putting courts in a really difficult position where they'd be having to speculate about, well, what are the accommodations for this symptom? What are the accommodations for that condition? And I can imagine the juvenile courts and the district court saying, hey, we're just not equipped to do that. So that's why the litigant needs to ask us for the specific accommodation, not just identify the condition, but tell me what you think you need so that I can evaluate that. So why is that wrong?
Well, I think the fact that the juvenile court, I think, has an affirmative obligation that they could have, or the juvenile court in this case could have at a minimum just ask for an assessment. That would have avoided both the Rule 59 motion and any issue. Now is ask for the assessment. Is the court should recognize when somebody raises the fact that they have a disability that it requires at least consideration by the court in the facts. And so I think what your question is suggesting is that you put the burden on the party. But I think in this case, the parent has raised sufficient information to trigger that obligation on behalf of the court.
So that's the very, very nugget of this case then, right? Whose obligation, whose burden is it to get the information? Does the juvenile court need to ask and require an assessment once a disability, an ADA claim is even on the horizon? Or is it incumbent upon the parent who is going to raise the ADA claim to present the information to the court in a way that allows for modification of the service plan or identifies what reasonable accommodation can be made for the parent, right?
I think that's fair. Although I think in this case, she did actually, in the Rule 59 motion, after the permanency goal was changed, did request a specific accommodation and said that she needed more time because one of the symptoms it did talk about in the Rule 59 motion anyway, is that she does require additional time to complete tasks. So yes, in answer to your question, that is a nugget, but I don't think it's the only one. So do you treat this as the typical civil case where somebody gets an expert or doesn't get an expert? Or do you, I think because it's a termination of parental rights, that those sorts of rules that you'd apply if somebody didn't hire an expert and in medical causation in the typical civil case, this is not the same thing. This is cutting off her parental rights to her child, and I think because of the importance of that, I think the obligation is on the court to make that imposition, put the imposition on the court to ask for the assessment.
Judge Christensen Forster, you're muted.
Thank you. Thank you, Mr. Stevens. And are there any other questions for Mr. Stevens? Does not appear so. Ms. Pierce and Mr. Peterson, thank you for coming back. Thank you all for your arguments today. Very helpful. We will take this matter under advisement and render a written decision as soon as we possibly can.